Picture this. A foreign billionaire donates millions of dollars to build a massive, state-of-the-art rural hospital. It's fully staffed, fully equipped. But then, almost overnight, the government steps in and takes legal ownership of the entire building, the land, and literally every single asset inside it. Could that actually happen? Well, under the newly proposed framework of India's FCRA 2026, the answer is a resounding yes. And this isn't just some minor administrative tweak we're talking about. We are looking at one of the most sweeping changes to civil society regulation in modern Indian history. Welcome to today's Explainer. Today, we are decoding the Foreign Contribution Regulation Amendment Bill and Rules of 2026. Whether you're a policy enthusiast, a focused learner, or especially a UPSC aspirant looking to totally master this incredibly complex legislative topic, you are exactly in the right place. We're going to break down this massive paradigm shift and give you a complete, highly structured study guide. All right, here's our roadmap for today. We'll kick things off with an introduction to the FCRA, break down the new 2026 framework, look at the tension between security and civil society, tackle the constitutional challenges, review some landmark legal precedents, and finally, discuss the balanced way forward. Let's get right into it. Section 1. Introduction to FCRA. Tracing the historical context. You know, to truly grasp the sheer magnitude of today's 2026 law, we've got to take a quick look in the rearview mirror. The way this legislation has evolved tells a really fascinating story about India's shifting priorities. The original FCRA was born way back in 1976, right in the middle of the emergency. Back then, the main goal was pretty straightforward, just curb Cold War-era foreign interference in domestic politics and elections. Fast forward to 2010, and the law was completely replaced to shift the focus heavily on NGOs, which is when they introduced those mandatory 5-year renewals. Then in 2020, the grip tightened even further. The government banned inter-NGO subgranting and slashed the cap on administrative expenses down to just 20%. And that brings us to the 2026 framework, which introduces asset vesting and a remarkably strict activity matrix. So the big takeaway here is that over 5 decades, this law has grown increasingly strict. It moved from simply securing elections to meticulously tracking physical brick-and-mortar assets. Section 2. The 2026 framework explained. Let's look at the key provisions. Okay, so this is where the major paradigm shift actually happens. We're moving way beyond just tracking liquid cash now. Think of the new Chapter 3A a bit like breaking a really strict landlord's rules, but on a massive institutional scale. Here's how it works. Step 1. An NGO's FCRA certificate is either canceled, surrendered, or even just unrenewed. Boom. That immediately triggers Step 2, provisional vesting. Instantly, all liquid assets and physical properties, like those clinics, educational campuses, or the land we talked about earlier, vest with a central government-designated authority. Now, if the NGO cannot get its registration restored within the statutory timeline, we hit Step 3, liquidation. The assets permanently vest in the government, they can be sold off, and the proceeds go directly into the Consolidated Fund of India. It is an immediate, automatic shift of property dynamics. And the new rules certainly don't stop at physical property. Every single nonprofit must now fit into a super granular matrix of 5 rigid domains: social, economic, educational, cultural, or religious. You also have to explicitly map out your geographic territory. If you want to cross state borders, or, say, mixed domains, you're going to incur structural step-up fees. Furthermore, the 2026 law introduces a deemed cessation of registration. It used to be that if your renewal was stuck in pending administrative review, you could technically keep operating. Not anymore. If you aren't explicitly renewed, your registration automatically lapses. We're also seeing expanded personal liability here. Directors, firm partners, and even the Karta of a Hindu undivided family are now legally on the hook as key functionaries. Oh, and notably, foreign citizens are generally barred from holding these key roles without central government approval. Now, a really critical threshold in this new framework is 10 lakh rupees. To weed out dormant shell companies, the 2026 framework mandates that an NGO absolutely must utilize at least 10 lakh rupees in foreign funds over the preceding 2 fiscal cycles just to maintain an active status. So, wrapping up this section, it's clear the 2026 framework is no longer just about tracking where the money goes. It heavily regulates physical assets, operational geography, and even the personal liability of the people running the show. Section 3. Security versus civil society. The dual perspectives. For all you UPSC aspirants out there, this is where you really need to put your analytical hats on. It is vital we examine these 2 opposing viewpoints impartially. On one hand, we have the state's goals of national security and sovereignty. The government argues this framework is absolutely essential to prevent foreign financial flows from funding legal interventions that end up stalling key national infrastructure projects. Think nuclear plants or mining sites. They also argue it perfectly aligns with the Financial Action Task Force recommendations against money laundering by tracking physical assets, and that it serves to balance religious freedom with protections against material inducements. But on the flip side, civil society has some very serious critiques. The biggest alarm bell for them is the total absence of judicial process. Chapter 3A permits administrative control of long-term investments without any prior judicial warrant. There's also the harsh reality that this massive compliance structure heavily burdens small grassroots rural welfare groups that simply don't have specialized legal desks. Interestingly, civil society also cites the FATF, noting that its 2024 mutual evaluation report actually cautioned against broad measures that sweep up the entire civic sector. They advocated instead for risk-based, targeted measures. So ultimately, this is a classic high-stakes clash between state security and grassroots survival.
Section 4. The Constitutional Challenges. Let's examine the friction points.
So how do these new administrative rules actually interface with India's fundamental rights? Let's de-jargonize these constitutional points for a second. First up, Article 14, which guarantees equality before the law and protection from arbitrary state action. The friction here? Well, the 2026 rules vest incredibly broad powers and a designated authority to seize assets without any mandatory pre-seizure hearings. Next, Article 19(1)(c) guarantees the freedom to form associations. The concern is that the rigid functional restrictions and geographic mapping we talked about could severely cripple an association's actual practical ability to operate. And finally, Article 300A, which is, quite simply, the right to keep your property. Transferring private charitable property into the Consolidated Fund of India purely via administrative orders raises some massive questions about proportionality. Let's actually zoom in on Article 300A for a second. No person shall be deprived of his property save by authority of law. I want you to ask yourself this. If a purely administrative order, without a judge's prior warrant, can liquidate a privately funded charity hospital just because a renewal form lapsed, does that violate the very essence of this right? As you can see, the 2026 law creates some serious, undeniable constitutional friction that the courts are inevitably going to have to untangle.
Section 5. Landmark Legal Precedents. Guiding the Courts.
Now, to guess where this is all heading, we have to look at how the Supreme Court has historically viewed fundamental rights when foreign money is involved. Listen to this defining quote from the Supreme Court in the 2022 case, Noel Harper v. Union of India. Receiving foreign funding is not an absolute fundamental right. The state can regulate capital entry to secure national safety. This is a huge precedent right here. It clearly underscores that when it comes to national safety and foreign capital, the state legally has the upper hand. The courts have explicitly validated the government's authority to build walls around foreign funds. But wait, that power isn't a total blank check, and this brings us to the famous proportionality test established in Modern Dental College versus State of MP back in 2016. The court ruled that any restriction on a right must pursue a legitimate aim, be rationally linked to that goal, and represent the least restrictive path available. In plain English, yes, the government can regulate foreign funds to protect security, but they absolutely must choose the least restrictive path to do so. Is liquidating a rural hospital the least restrictive path? That's the billion-dollar question. To recap, the courts are constantly having to balance this overwhelming state power against individual constitutional rights.
Section 6. The Balanced Way Forward. Balancing security and civic autonomy.
So, how do we actually fix this? Based on our source material, here are 3 forward-looking strategies to bridge this gap and resolve the ongoing legal and social tension. First, risk-based tiered enforcement. Instead of a blanket approach, the state could use a calibrated risk model. Give grassroots development and health groups simplified compliance, while keeping strict targeted tracking for high-risk border regions. Second, judicial integration. Simply amend Chapter 3A so that before the government takes control of long-term welfare property, they actually need approval from an independent judicial officer or tribunal. This instantly restores the rule of law. Finally, safe harbor protections. Establish explicit timelines, ensuring an NGO's registration remains provisionally active if their renewal is delayed due to slow administrative choices, not their own fault. Just to recap, these solutions could brilliantly protect vital grassroots operations while maintaining the strict national security the state demands. All right, UPSC aspirants, listen up. Here is the ultimate test of everything you've just learned in this explainer. Look at this mains practice blueprint essay prompt directly from our source material.
The Foreign Contribution Amendment Bill 2026 marks a paradigm shift from the regulation of foreign capital to the potential control of civil society infrastructure in India. You were asked to critically analyze this in light of constitutional, socioeconomic, and internal security implications. Everything we've covered today, from the 10 lakh threshold and asset vesting to Article 300A and the proportionality test, gives you the exact framework you need to absolutely crush this answer.
I'm going to leave you with this final, pretty provocative thought. Based on the evidence, the legal precedents, and the stark reality of how this law operates on the ground, does the FCRA 2026 represent the strictly necessary regulation of foreign capital to protect a sovereign nation? Or is it an overreaching mechanism designed to completely control the very infrastructure of civil society? You've got the constitutional and legal frameworks we've discussed today, so what do you think? Thanks for hanging out with me for this explainer. Keep up the great studying, and I'll catch you in the next one.